Good evening, everyone, and welcome to tonight's event, To Be or Not to Be. It's a short conference on the topic of international law. Before I tell you why we chose this particular theme, I'd like to introduce you to the editorial board. Even though I have the pleasure of standing here and welcoming you all, it could never have taken place without the tireless efforts of everyone on the Westminster Law Review board. My name is Sharif El-Gabaili. I'm the editor-in-chief. On the end there we have Joanna Economopoulos, who's our marketing director, Shamima Chowdhury, who is the executive director, Pravin Jairaj, who is our academic editor, and Serhat Yilmaz, who is our second academic editor. The idea behind tonight's conference was really as a result of an interest in the conflict between domestic and international law, or specifically the conflict between the legal obligations at the domestic and international levels. A short while ago, I'm sure you'll all recall, the WikiLeaks founder Julian Assange claimed asylum at the Ecuadorian embassy as a result of a European arrest warrant issued by Sweden, where he was wanted to face charges for alleged rape. This particular European arrest warrant put the UK in a very difficult position. On the one hand, it had to honour the obligations of the European arrest warrant. It had to hand him over to Sweden. It had an obligation to do so. On the other hand, it also had to honour the Vienna Convention on Diplomatic Relations, which stated that diplomatic premises are inviolable under international law. So the question really then came about which norm was superior and which law should the UK obey and why. Those of you who follow current affairs will know that he remains in the Ecuadorian embassy and despite attempts or threats, I should say, by the British authorities to storm the embassy, they didn't do so. Now obviously this would have been very problematic in terms of international law because firstly it would have set a precedent for the breaking of these international norms, and secondly, of course, we can't forget the outrage that the UK government had at the storming of its own embassy in Tehran late in 2011. So the wider question then remains how a state's obligations in the international plane can affect its domestic policies and actions. Let's not forget that international law is not all about human rights, the avoidance or existence of conflict, or even just diplomatic relations between states. For the most part, they are highly ramified norms or systems of authority that allow, for example, piracy to be suppressed, ships to be given passage, and goods to be carried. Indeed, tariffs and duties are also accordingly adjusted and negotiated. So law can be seen as an evolutive and dynamic field. These and some of these topics are ones that are submitted to the Westminster Law Review, but they also featured in tonight's conference. In a slight change to our original program, which you have in front of you, originally our keynote speech was supposed to be delivered by Professor Flood after we had a speech from Helene Albrecht, one of the published authors from the Westminster Law Review, but due to time constraints we've had to switch that. So Professor Flood will be delivering his keynote speech first, following which Helene will be giving us a short speech about her recent article, Diner for All, or How Not to Compare Apples and Oranges. So without much further ado, I'd like to introduce you to Professor John Flood.
Thank you very much. This is about international law. What I want to talk about tonight is not so much international law as perhaps more transnational law. International law sort of presupposes the state is there doing things and so on. What I want to emphasize is when the state is absent, which is happening more and more these days. Why? Because states are constrained, states are broke in many places, they haven't got any money, and so other people have to do the job that states would normally do. We think of states as making law. Max Weber, the legal sociologist, said law is the legitimate application of violence by the state. Well, you think about it. For example, I think today the person who was responsible for attacking the hotel in India a few years ago was hanged in India. There you have the sort of example of the legitimate, supposedly, use of violence by the state. But I'm not really so concerned about violence or anything like that. What I'm concerned about, though, is colonialism. Now, you know, Britain has always been an empire. Britain has, or thinks it always rules the waves. If you go to the last night of the proms, they're all sing Rule Britannia. And there's something rather naive and you know, inspiring, if rather despairing at the same time about that kind of attitude. But in other ways, what Britain does not do by the state, it's now able to do through various other organizations and institutions, which in some ways perhaps are even more powerful than the state. So I'm not really going to be talking about international law, as I've made clear, but about transnational law. Transnational law is a different way of seeing how law moves around the world. And these days, law has gone global in a big way, just as lawyers have gone global. Just as I've gone global, I've discovered this year, I've literally gone all the way around the world doing various things. In the next 2 months, I will be in Switzerland, India, and Australia. So there's something to doing work on globalization. It actually gets you global at the same time. You know, it's a good side benefit to that. I recommend it. Now, leaving aside that, let me just go back to 1977, way back. Why 1977? There was a commission to study the legal profession and the legal services market called the Benson Commission. And it called in evidence from everybody around, all the lawyers and the Law Society and all those sorts of people. And it also got some evidence from a rather small, relatively unknown group called the City of London Solicitors Company. Now, I'd never heard of this until I dug out this piece of evidence. But what the City of London Solicitors Company said, and this is the society that represents all the big law firms, you know, the ones you hear about, Slaughter and May, Clifford Chance, Allen Overy, all those firms. It said, we want to tell you what it is we do. And what we do is we market a product, and that product is English law. And English law is in competition with American law, French law, Dutch law, and any other kind of law you can think of. Now, first of all, this was quite a radical statement to make. It also seemed to be something of an incomprehensible statement to make. What do you mean, law is in competition with other kinds of law? Well, if we take transnational law, then what we're talking about is when businesses and people come together to do trade across borders. Now, you've all heard of freedom of contract. So within the freedom of contract, you have the freedom to choose what kind of rules you're going to use to govern that contract, what kind of dispute resolution system you're going to use if it goes wrong, which it probably will, and you know, where the money will go, and all of these sorts of things. Now, if you have that kind of freedom, then you choose what kind of law you want, what kind of lawyers you want, and what kind of dispute resolution system you want. So let me give you an example. And it all comes down to mistrust, of course. Nobody likes another's legal system or lawyers because they don't know them, they don't trust them. So imagine an American corporation is going to build a hospital in Saudi Arabia. This is what's called a turnkey contract. Basically, they agree to build a hospital. When it's done, they hand over the key to the owner and say, here's your hospital. So imagine the Saudi government is commissioning a new hospital from Bechtel Corporation, a big construction corporation in California, which is going to be financed by bonds which are going to be raised on the London capital market. Okay, So what law applies in that contract? Well, since the Saudi government is the owner, it says, well, we'd like to use Saudi law, Sharia. We know it, we trust it, we like it. The Americans and the English say, no, we're not so keen on that. And by the way, you haven't got a very good reputation with certain aspects of Sharia law, whether that's deserved or undeserved. Doesn't really matter. It's all to do with perceptions. It's what people think, not what actually happens on the ground. Plus, your commercial law is relatively underdeveloped compared to ours. So the Americans say, no, we want to use American law because that's what we know. And then the Saudis and the English say, no, we don't want American law. You guys, you go mad in the courts. You've got all this discovery. It costs an absolute fortune. And why the hell would we want to go there? So the English say, well, that leaves us. We've got very easy courts. We don't have the kind of discovery that the Americans have. We don't do the sorts of things they might do under Sharia law. But our lawyers are expensive, but that's because they're good. So they're worth it. And eventually, what will probably happen is, yes, they may well use English law. They may well then use an arbitration system under something like the International Chamber of Commerce or Stockholm or some other system, which will allow them to define the rules in the way they want. Now, to go back to what I said about the City of London Solicitors Company, there are effectively in the world today two legal systems that dominate all transnational law, all international trade. One is English law, and the other is New York state law. Not even American law, just New York state law. Why? Very simply, London and New York are the main financial centers. And if you think, well, yeah, but China is now getting big, let me put this into context. The money that flows from legal services globally is around about between $500 to $750 billion. There are something like 3.2 million lawyers in the world. Of that, the United States has about half of that money and has a third of the lawyers. They've got over 1 million lawyers. Of that, the European Union has about $250 billion worth of that money, and just under 1 million lawyers. Within that, the UK has $40 billion and 120,000 lawyers. And then Asia has about $69 billion worth of legal revenue with, far fewer lawyers, 300,000 lawyers or something like that in the whole of Asia. So in terms of sheer scale, Europe and the US completely dominate. In terms of numbers, the US dominates even further. And that's not difficult to see. Most of the main investment banks are based in New York and London. So these are the two main capital markets. If you want money to do something, you basically come to London or to New York. Recently, a number of Chinese digital companies have gone to market to go on the stock exchange. They've either gone to New York or they've gone to London, not Shanghai, which is what we would expect. So there's a very powerful move. Now, once you've established this kind of ascendancy, it's very difficult to shake it. How did the English get it? Well, they got it in the 19th century. They got it because people wanted railways. So in the middle of the 19th century, everybody's building railways. The English, the Canadians, the Argentinians, the Indians, the Australians, well, everybody. Everybody was building railways. So what do you need to build a railway? You need lots of money. Just look at the Crossrail project going across London at the moment. Where do you get the money? You go to the banks. Where are the banks? They're right here. And who do the banks use? They use the English law firms. So in the 19th century, all the English law firms were going out around the world doing these railway construction projects, contracts and things like that, bringing in all that business, that legal business, back into the UK through the English courts, and then so completely consolidating what it is that they do. The Americans, of course, have come to compete with that, but still, the English legal system is very strong in this respect. Also, we export more of our lawyers around the world than any other country. Our law firms are huge. We've got the two largest law firms in the world based in the UK. Clifford Chance, which has got close to 4,000 lawyers, DLA Piper, which has over 4,000 lawyers. Go back 20 years, only one law firm in the world measured 1,000 lawyers. The growth has been phenomenal. Why? Well, there's been an expansion in trade. There's been an expansion in regulation. All of economic life is regulated now. More regulation, more lawyers. It's just inevitable. Keeps going. So, where does this leave us? Well, what it leaves us in is a position now where the market is getting so competitive. The Chinese are now producing big law firms. The Americans are really pushing. The Dutch are trying to grow their law firms. Even the Italians. I think we've got one or two Italians here. Yep. Even they're thinking about going big. That probably means going to maybe 12 lawyers, not 2,000. But, you know, bless them. Their heart's in the right place. Now, so the world, however, is not standing still. 10 years ago, Australia took a radical step, which was to allow law firms to incorporate, to become companies, to go on the stock exchange, just like any other company. You might think, this is appalling, this is terrible, this is unprofessional, it's not very nice, it's not the sort of thing. However, there have, in the last few years, been very strong currents. One is on the competition side of things. Any institution that tries to justify having a monopoly in something will find itself in a very difficult situation actually trying to justify that. In the early part of the 21st century, the OFT, the Office of Fair Trading, analyzed legal services and said, we think they have monopolies which are no longer justified. We should allow other people to come in and deliver legal services, not just lawyers. We should also allow any kind of organization to offer legal services. The result is, after a number of reviews, we had the Legal Services Act in 2007. All of you are going to be affected by this act. This is the single most important piece of legislation that has ever been passed that's going to affect your careers as legal professionals. And I suggest you read, if anything, just the very first section of it, because it sets out clearly what it thinks the legal services market ought to be like. Yep, you're going to promote the rule of law. Yes, you're going to be convinced to do things in the public interest. But at the same time, you will also have to think about consumers. For the very first time, consumers have been mentioned in respect to the legal profession. There will be competition between providers of legal services. And there will be permitted non-lawyer ownership of legal suppliers. As from this year, we now have these. We now have an open market in legal services supply. What does this mean? It means, perhaps the most clear example that we can see, although this is not global, I'll come back to that, is the co-op. You all know the co-op? How many of you live in Hackney? Anybody? Well, me? Am I there? Oh, okay. There's a new co-op just opening. I'll make the point. But the co-op, for example, is an organization that runs grocery stores. It has a bank. It has credit, insurance, and it also has the largest funeral supplier in the country. It is now going to have probably the largest legal supplying outfit in the country. In 2007, Co-op Legal Services, as it then was, had 3 lawyers. In 2011, it had over 300. It has now just advertised that they've got 3,000 positions to fill in legal services. This is a huge expansion. They will do it in ways which most lawyers will not understand. They won't charge by the hour, they'll give a fixed fee. They'll do a lot of work online, They will outsource a lot of their work to India, where lawyers are trained in exactly the same way as you are, but at a third or a quarter of the price. So even at the kind of domestic level, we will see law spreading around the world. But the other aspect of that is that people can now invest in law firms, buy law firms. Some of you may have seen a program called Dragon's Den on TV, where people come and pitch ideas to be funded by these billionaires. One of those has just gone out and bought a law firm in the Midlands. He has great plans for how that law firm will expand and develop. It won't look anything like a law firm in the future. We are seeing even more strange occurrences. Let me give you one. BT, for example, the telephone people. Now, because they're such a big company, they have a lot of vans, a lot of trucks. They go out there all around town, everywhere. As a result, they have a lot of accidents. So they have a claims department that deals with the accidents. That claims department is now going to become a law firm in its own right. It will be taken out of BT. It will become a law firm, and it will just do claims management work for anybody else who has lots of trucks and lorries and things like that. But it also means that as people can take investment, then they can start thinking about doing things with money which they would not have otherwise had. The thing about lawyers and law firms is they're very short term in the way they think. They think from year to year. What are my profits like from year to year? They don't invest for the long term or anything like that. If you become a company, you start to think more long term. If you're investing in more technology, more highly specialized people, you start thinking about the long term. Well, what does it mean to invest in more technology? These days, we can put every single case that has ever been tried in the courts in this country, in the US, we can put it into a database. Every single case. Now think about when you go out and do your bit of research with Lexis or something like that. You look for a particular case or something like that. Supposing you are Apple or Samsung, constantly getting into intellectual property fights at a global level. If you can interrogate, examine every single case, and you know you want to sue Samsung or HTC or Sony or some other company, and you're worried about them suing you back, you can now mine all of those data to find out exactly what kind of decision would be rendered given your kinds of circumstances. We haven't been able to do that up to now. This is going to change the entire way law is done. There will still be the need for the specialists. Somebody's got to come up with the idea, the concepts. But the actual grunt work, the work of the research, finding all of those things, that can be done by computers far faster, far more efficiently than a human can do it. Take discovery, for example. If you're involved in global litigation around the world, you can either hire lots of people to go into rooms and sit in front of computers and go through lots of emails to find out which should be admitted in discovery and which should be excluded, or you can construct an algorithm, feed it into the computer, and have it go through however millions of emails you've got in a matter of hours, instead of weeks and months that it would take humans. So already we are, in the global world of law, expendable to a large extent. You need somebody to think of strategy for tactics. That's going to be done by machine. It will also be done by, in some ways, the lowest cost provider. And at the moment, the lowest cost providers are in countries like India, Philippines, Vietnam, Cambodia. They're not in the UK. They are, at the moment, in Northern Ireland, where a number of the law firms have set out outsourcing departments in Belfast. They may be in a few other small places, but primarily they're going to be in these low-cost areas. So the major law firms are going to recreate themselves as probably more efficient, more technological, more strategic in the way they use data. And what will happen as a result of this is if you can begin to predict what the outcome of a particular situation is, because you're able to interrogate the entire body of cases in existence, we won't need to go to trial. The trial will become expendable too. The trial is already disappearing. And so we will be getting more to negotiate settlements, which is what lawyers will need. So lawyers are going to need a whole array of different skills in this world. They're going to need to know how to use technology. They're going to need to know how to negotiate. They're going to need to know how to manage businesses. Oh, and on top of that, they should know some law as well. That's not a big ask, but it's a little bit more than what you've got now. In actual fact, what you have now is a situation which is far more volatile, far more dynamic, and a lot more interesting than it used to be. Because the old way was expensive, it was time-consuming, it was difficult. These days, it's going to be a lot easier, a lot faster, a lot more interesting, and I think for you, well, you know, it's a brave new world. I don't know how it's going to turn out. It's going to be up to you to think of ways of doing things. Yesterday, I was talking with the general counsel of a firm called LegalZoom. Has anybody heard of LegalZoom? Yeah? If you haven't, you soon will do. LegalZoom is an entirely online service for delivering legal solutions. Wills, documents, contracts, leases, employment contracts, you name it, trusts, everything online. With the aid of computers, with the right programs to produce the results. You don't need lawyers to do that anymore. And what LegalZoom have done is they've tied up with a law firm in the country which has offices throughout the country, Quality Solicitors, and the solicitors themselves will be using this technology to supply their customers with all the legal things they want. Admittedly, there still will be areas, maybe welfare, crime, and so on, where we need the more human interaction. But for a lot of what passes for legal business these days, humans are often the very last thing you need. The machine is here, the machine is going to dominate, and you better learn to love the machine. Good luck to you.
Thank you, Professor Flood, for a very interesting speech and for identifying that there are many different sides of the concept of conflict in the field of law. That, in this particular case, between the domestic systems in the transnational law. I'd like to now introduce Helene Albrecht, who will be speaking about her recent article that was published in the Westminster Law Review. So if you would like to come up and speak to us. Thank you.
Hello, everybody. First of all, thank you very much for inviting me to give this talk tonight. I'm delighted to be standing here, and I just wanted to congratulate you to your project, the Westminster Law Review, because I'm following this since I left Westminster Law School last year. And I have to say, it's just impressive how you're advancing and how your progress is made. I really like the new design, and I find this fantastic that you have the legal daily news, which everybody can access, and I'm often making use of these services. Yeah, this was one point. The next thing, thank you also for publishing my article, which was quite interesting. In the end, I knew it was a bit controversial, my approach. I hope you all read it and you know what I'm talking about. My article took kind of a different stance, and it has lots to do with what we just heard from John Flott, that I just wanted to point to the difficulties when we have constructed law and when we have kind of mechanical law, and which kind of difficulties this actually raises. And in this sense, I put a lot of different perspective into one article, very different from a legal analysis. Sorry, my pronunciation sometimes is struggling. Where you normally take a piecemeal approach, and I was kind of looking at different angles, taking the perspective of a concerned consumer, taking the perspective of a lawyer, taking the perspective of politicians dealing with outcomes of law. And this was actually my stance, and I put this all together and will tell you how, what it is about. The main theme of my article was actually food, and I was looking at food and the mismatches which arise out of legal economic ramifications. And there was one mismatch between the consumers, consumer expectations relating to health and protection of consumers, and food regulation actually. And there was a further mismatch between economists who created kind of international economic law and the political outcome in the end, as nobody was really satisfied with the result. This is mainly the content, and the structure works like that. I found 3 nice cases from under the WTO, World Trade Law, and these cases related to poultry. And I was just amazed because I wanted to write about the cultural problems with food, but in the end, these poultry cases turned out to serve perfectly my purposes, because there were a case between the US and China for poultry flown from China to the US. The US didn't want to have the poultry because it was treated with hormones. Then it went back the other way around. The US wanted to kind of safeguard their poultry exports to China, and there was a case with dumping fees. There was Russia, who got poultry since the 1980s, and in the end didn't want this poultry anymore, and this was aid shipment initiated by Bush, and in the end this failed because Russia is now kind of self-independent and doesn't want. So you saw all this poultry flying around the globe with not making any sense at all, and causing a lot of economic losses and a lot of distress. And from this point, I introduced to the different agreements under the WTO law, and point to kind of the legislation, how this comes about that we are flying our agricultural goods over the globe, and which kind of agreements are behind this. Yes, and from this perspective, I approached the consumers and citizen perspective, and there were lots of cases since the 1980s already, where mothers and people all over Europe, for example, discerned abnormalities after the consumption of meat and tried to bring a case, and the European Union established food regulation towards meat, that no hormone-treated meat would be allowed in Europe. This was in 1980. But then we had the Uruguay round and the globalization effects, and law would establish even retrospective that this meat had to be imported by the European Union. Canada and US had already invested in this kind of hormone-treated meat, and there was a lot case, and then the whole thing started. So just read the article and we'll know more about this. Then I started to feel the mismatch between consumer perspectives and the tough regulation coming from international economic law, going down to the European stage and shifting to all the European member states, and I felt the difficulties. Yes, though this was the structure, I end up with a positive view on kind of law we can use to mitigate. And I was asked why I was inspired to write this article, and I wrote this article during my year at the UCL, where I did a master in environmental law and policy. And it just happened that I was studying all this law, international energy law, environmental law, European environmental law, world trade law, when we had this upcoming conflict between Anglo-American countries and the European Union. And over the whole year, I followed the conflict, me as German, quite interested in the whole issue, what was going on between Britain, Germany, what did countries expect from Germany. And the conflict got tougher and tougher and kind of aggravated. And I learned about the law and felt that the law has pretty much to do with this conflict and stands behind that. And it was kind of the initial idea then that I wrote this article. My personal intention was that I'm a very green person by nature. I can't help it. I'm somebody from the 80s in Germany. And I have to say, this is something which nobody understands here in Britain, but we are green by kind of commitment, really, because we are the generation after the war, and our generation that just didn't want to do any harm anymore. So our green commitment was very much linked to the disarmament, and we were very upset with the rearmament on German territory. So for us, it was really natural that you would avoid nuclear energy, that you would turn to organic food and so on. And we're dealing with this since the 80s. And for us in the 1990s, it was really kind of a shock when we got this American legislation. So I'm personally affected. And when I came to the UCL, this is my second career, I was really keen on learning something about sustainability and thought I'm doing something for my children here. And I'm kind of using the law for sustainable purposes. But in the end, the things really developed very differently. And you could feel the huge discrepancy between international economic law, which is binding for states, and international human rights law, international environmental law, international humanitarian law, which are all soft law guiding principles. And I felt there was a huge mismatch between these systems, and this was another reason why I also needed to take this round and broad perspective with focus on food. What I found also interesting about food was that food is something which is heavily regulated, so it falls under the public domain, but otherwise it's a very private thing. And I felt also this was a controversy. I was enjoying the atmosphere at the UCL, which is really a global university. I mean, this is also global here. You see faces from all over the globe. And we had lots of nice dinners together, and we would gather around food. And then you would learn about these cases where people got really very aggressive. Yeah, the US and Canada were hugely disappointed with Europe not taking GMO products anymore. Otherwise, GMO products are also produced by Bayer, Leverkusen, big firms here in German territory. The Americans didn't want to have GMOs neither. So I also found a big difference between what you find on the internet, NGOs, citizen movements, citizens' initiatives, and so on, and that what really happened on the legal stage. And this connects somehow to what Professor John Flott said. In my opinion, it's not only that the law is about machines and about turning away from humans, it's just the opposite. We are getting into more and more conflicts and huge crises, and I think there's a lot to do for other spheres of law. And to conclude, what really kept me up and really helped me a lot was the discovery of an American lawyer. And this man was actually a botanist, and he was born in 1870 and became a lawyer by chance because his father was a lawyer and he wanted him to help out in his own business. And he sent him to Harvard Law School, and within 1 year he got such an insight into the law that he was talking in front of the American Bar Association, and his very first speech in 1906 was about the dissatisfaction of the public with the administration of civil justice. And the speech was immediately kind of a scandal, and all the lawyers sitting at the Bar Association were kind of offended, and it was not even printed. But there were some people sitting in the public, and he was appointed a dean in somewhere in North America, and became dean of a law school without having any law degree, actually. And this was discovered later on, so he became a honorary professor, and so on. And actually, John Roscoe Pound was the Harvard dean and kind of created American jurisprudence. And he was perfect in several European languages, so he had huge insights into the continental legal system, into the British system, and the American system. And he created his own amalgamation between kind of civil Roman law and British law, which became sociological jurisprudence. And for him it was very important not to look only for the law, but also for the effects the law takes on society. This was one very important aspect. And also he differentiated between law and laws. And his analysis is really so helpful for me nowadays, because for him law was something which is found, which is there. and it's in people's mind, in people's brain, in people's understanding. And laws are made to regulate, and they are depending on geography, on culture, on history, and they may change and they may be contemporary. So he differentiated between these two systems, and I found this quite interesting. And when I look at our environmental problems, so degradation of our pure environment and the climate change issues we simply can't tackle with our legal systems, apparently, then I think there's a big case to make. Yeah, this is actually my contribution. Yes, I want to thank you. Questions, if yes.
I'm not sure whether there are any questions. Unfortunately, we couldn't take any questions with Professor Flood, but if there are any questions,
yes.
I think we have a mic somewhere.
Would you like to take this one?
No, there's a hand like that.
Thanks a lot for the very interesting passionate talk. I have actually a few comments or questions. The first one, I was really curious to know more about the specific case that shocked you about Germany and Britain. And then I have a question about.
Basically, I find it very interesting. You kind of distinguish between the private dimension of food, which can be dictated by religion, morals, or taste as well, and the public aspect of food. Of course, food has, as we say in economic, externalities. You can, if it is GMO, can have problems on other kind of environmental issues, I mean, or pollution, or public health, animal welfare, things that actually need probably to be regulated. And here we come to the issue of law. So I don't understand here if you advocate for a more international approach or a more national approach. And I would like to hear from you what you think about science in general. Do you think that there is an objective, universal truth or standards about food, or here again it's something more political, and then all this has repercussions on the legal system and how laws should approach probably these things? So, well, this is my kind of...
Yeah, very good questions. Just about food, I think food cannot be regulated kind of in a global manner because it's very regional, actually, and also very cultural-based. And if you read my article, there was one book quoted from 2001, written by an American professor, and she was looking at the culture of food. And she was already kind of anticipating the stress the regulation under the WTO would cause, which is the SBS agreement, and this is the agreement on phytosanitary and sanitary measures. This means countries can protect themselves, whether they want particular food as imports or not. So this is one issue, and I mean we are dealing with food which is kind of manipulated since the 60s, 70s, and what I found really interesting when I studied these cases. In the 1960s, we had a really green movement in America. The US was very, very environmentally friendly, and they would oppose any pesticides. And you know, there's this Rachel Carson with Silent Spring. Yeah, there was a huge movement. They simply didn't want to have pesticides and these kind of degrading factors. And at the same time, the European community was building up, and we had a major chemical industry and coming up with pesticides and so on. And Europe turned green in the 80s, and we had this mechanical and very aggressive kind of forcement of food. And you know, we had these milk mountains and butter, milk lakes and butter mountains and whatever. So this was already a regulation which didn't cause benefits. You had, in the end, too much food. And what my article tries to point out, that food is always related to other products. And it's not about food, but it's a whole industry which sits on the back of food, like transport, like chemicals, like pesticides. So in the end, we are running on our economy on basic things. Yeah. So with one apple, you all of a sudden have scientific requirements. You have chemicals on the apple. You have kind of food agency who needs to look at this apple. So it's actually a major involvement, and the legal profession is also benefiting from that. This is one point. Therefore, there is a big thing with science, and I can possibly point this out in the case of GMOs. Yeah, there was lots of talk. Is GMO products, are they good or not? And it's still an issue for Britain. Firstly, you can also see GMOs as kind of an imperialistic thing. Yeah? As soon as you export GMOs, the taker and receiver of GMOs is kind of bound because he's depending on you. This is one thing. Then GMOs, there's a lot of scientific uncertainty. And this is, I mean, you can find 50-50 scientists who say it doesn't cause any harm and scientists that this is very harmful because we don't know exactly how sexual reproduction functions. Yeah, and GMOs just cut off. Yeah, you have no sexual reproduction, and this is exactly the process we don't understand for now. So you don't know what really is missing when you have a GM product. And actually we have now really examination which confirms that it's not really good. Yeah, this dying of bees is something which is really important, very distressing. Yeah, and you had Poland, there was a bee population of 80% just dying out. So these are these issues, and the European Union takes a stance towards GMOs, for example, that every member state can decide now on its own whether it wants to have GMOs or not. But otherwise, of course, now we have this stress and this pressure on Europe, and therefore I guess that member states tend to re-establish and open their doors for attracting investment. These are the issues which I really I'm concerned about. This is the last question was, I don't know.
Well, that was basically about what type of regulation then you would advocate, if any, about food.
I think it's about spatial environmental justice, and I have to say in the last years European legislation was moving towards this regulation. And what's also a very important aspect, this kind of industrialized food supply doesn't give much employment. This is something which I'm worried about. So we have now a generation of unemployed young people, yeah, who have nothing to do. And when you Google, there's a fantastic research on food production, which is not GMO-based, but it's kind of nevertheless very sophisticated. So it could be kind of a very fulfilling profession, actually. And I have to say, in Germany, it works. Yeah? So the profession of a farmer is now the third best reputed profession after teacher and doctor. So this was something which made me really nervous when I felt there's such a stress between, and it's very interesting because the countries who promote this food like biotechnology, these are Australia, New Zealand, Canada, and not the continent. And I mean, if you have ever eaten an Italian tomato or so, you know what the thing is about Italian and continental and European food. So there's a discrepancy, yeah? So countries who are not really famous for their food quality try to impose their food requirements, and this is a big issue, I feel.
Are there any more questions?
Hi. I just wanted to ask a question about whether you think sustainable development has a negative impact on sustainability as a whole? Because you talked about sustainability.
Yeah. So when I was looking at these poultry cases and learning about the losses these cases actually caused, I wouldn't say that sustainable development can have negative impacts, and this is something which is suggested. And I felt the stress we are having last year has had much more to do with the environment-economy divide, and nobody is addressing this because still people suggest that economy and environment are not kind of reconcilable, which is not true, in my opinion. I mean, we have already wasted our resources and we have driven the whole environment bust somehow. You really need to say, and I thought last year it was kind of a last chance to turn the wheel and embark. And nevertheless, the economy is not working. So I don't understand this logic anyway. Yeah, so how can we waste all your resources and end up in a constant disaster? Every 4 years you have a new cycle of depression and recession, and then assert it has to do because you don't waste enough of our resources. It somehow doesn't fit. And if you study this very carefully, you see there's a lot of manipulation, and also with our fossil fuels and renewables, and we're just experiencing that here in the UK now. So that's, I would say we would really have to, in a global context, learn to be sympathetic with other countries and at the same time focus on local spaces. It's my opinion. And learn from each other. And I also think that competition, global competition, is possibly not the last word to be said. That's why. Okay. Good.
Okay, thank you, Elaine.
Yep.
Just before we wrap up tonight, we should probably discuss the next edition of the Westminster Law Review. So to speak to you a little bit about that is our Executive Director, Shamima Chowdhury.
Thank you all for attending. So I'd just like to inform you that the Westminster Law Review is currently accepting submissions for Volume 2, Issue 2. So you're therefore welcome to submit abstract articles, book reviews, as well as comments. The final deadline for submissions is 27th of January 2013. If you require help in writing articles or formulating your dissertation to become an article, we have a writing workshop on the 21st of January as well, which Dr. Lisa Webley will be hosting, so you're more than welcome to attend, but please note places are limited, so do RSVP at info@westminsterlawreview.org. If you have any questions regarding the submission process, all you're required to do is simply go onto the website under submissions and you just have to upload your paper as one document rather than two separate like you would do on Turnitin and press submit. So does anyone have any questions regarding submissions or the Westminster Law Review generally? No? Oh, wait. No? Okay. Great, I'll hand over to Charlotte. Thank you. No, that's definitely
Very eloquently put. Thank you, Shamima. Right, so then I suppose that brings us to the end of the conference. There are refreshments at the back. And if you'd like to mingle or kind of discuss, then feel free to. We will not bite very hard. And yeah, thank you all for coming. Thanks.